Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to The Deep Dive, the show where we slice through the noise, unearthing the most vital insights from stacks of research to give you that unfair advantage of being truly well-informed. Today, we're plunging into a world that can feel incredibly vast and complex. The landscape of innovation.
Yeah, they really can.
Imagine having a precise map that doesn't just show you where the pitfalls are, but also guides you to hidden treasures and dramatically accelerates your journey to creating something new.
Yeah.
That, in essence, is the power of patent searching.
It's a fundamental truth. While patent searching might sound like a highly specialized, perhaps even dry technical skill,
Right.
it is absolutely indispensable for anyone who's innovating, building a business, or even investing in new ideas.
Okay.
This isn't just about protecting your ingenuity, it's the critical process that can literally shield you from monumentally costly legal battles.
Wow.
Reveal your competitors' next moves, and keep you strategically ahead in a rapidly evolving market.
Our mission in this deep dive is to demystify that complexity. We're going to show you exactly why patent searching is so profoundly important. Break down its different types with real-world examples and compelling case studies that truly highlight the stakes.
Yes, those are key.
We'll reveal the powerful and often surprisingly free tools readily available to you.
That's right, free tools.
And most importantly, equip you with the practical strategies you need to conduct effective searches yourself. Consider this your shortcut to mastering a truly crucial aspect of intellectual property.
We have distilled our insights from comprehensive guides on patent searching, packed with practical, step-by-step instructions, clear definitions, and some genuinely fascinating case studies. These examples, particularly from the pharmaceutical and technology sectors, vividly illustrate how a smart patent strategy can dictate everything from market entry to multi-billion-dollar legal outcomes.
So where do we start? The foundation.
Let's start with the foundational question. You know, before diving into this, I might have assumed the entire patent document offered protection.
Me too, honestly.
But you're highlighting the claim section as the absolute legal heart, the real definition of what's protected.
Right.
Does that mean you could have a brilliant idea explained in the specification, but if your claims are poorly written, your protection could be almost worthless? That's a perceptive observation, and it cuts right to the core of why careful drafting and thorough searching are paramount.
Okay.
While the specification describes the invention, the claims are the legally binding fences that define its exclusive boundaries.
The fences. I like that.
A brilliantly conceived invention with poorly drafted claims is like building a magnificent house without putting up solid walls. It's vulnerable to trespass.
Makes sense.
This is why, when disputes arise, the legal battle largely revolves around the interpretation of those claims.
Okay, so before we dive into the how, we need to truly understand the what. What exactly is a patent, and why is searching for them such a big deal? I mean, beyond just having a good idea, why do I need a piece of paper from the government?
At its core, a patent is a legal document granted by a government authority like the United States Patent and Trademark Office or USPTO.
Okay.
Or for those of you in India, the Indian Patent Office.
Got it.
What it does is simple, yet incredibly powerful. It gives the inventor exclusive rights to their invention for a limited period.
Limited period. How long?
This is typically 20 years from the original filing date of the application.
So it's essentially a temporary government-sanctioned monopoly on your unique idea. That feels like a massive power.
It is, but there's a crucial and elegant trade-off, a fundamental exchange at the heart of the patent system designed to benefit everyone.
A trade-off. What's the catch?
In return for these exclusive rights, this temporary monopoly, the inventor must publicly disclose their invention in full detail.
Oh, okay. Full disclosure.
This means publishing all the technical specifics, allowing others to learn from it. Once that 20-year period expires, that knowledge then enters the public domain, becoming freely available.
So everyone benefits eventually.
This system is a brilliant balance. It incentivizes private innovation by rewarding inventors while simultaneously fostering public good and future progress by ensuring knowledge is eventually shared.
That makes a lot of sense. So it's not just about locking things away forever. It's about a measured, beneficial release of knowledge that fuels future inventions.
Exactly.
And I've heard there isn't just one type of patent, right?
Yeah.
It's not one size fits all.
That's absolutely correct. There are three main types, each covering a distinct facet of innovation.
Okay.
And understanding the differences is key to knowing what you're even looking for when you search.
Let's break them down then.
First, we have utility patents. These are what most people immediately think of when they hear patent.
The functional stuff.
Right. They cover functional inventions,
Yeah.
new and useful machines, manufacturing processes, articles of manufacture, or even compositions of matter.
Like a new engine or a drug.
Think of a revolutionary new type of engine, a novel drug formula that cures a disease, or a complex software algorithm. It's all about how something works.
Got it. Functionality. So if I invent a new way to purify water, that's a utility patent.
Precisely.
What about if I invent a new look for the water bottle?
That brings us to design patents. These protect the ornamental design of a functional item.
Ah, the aesthetics.
It's not about how the water bottle works, but how it looks, its unique aesthetic shape, the distinctive pattern embossed on its surface, or its overall visual appeal.
Okay.
These are incredibly important in consumer goods, fashion, and electronics, where appearance drives sales.
So pure aesthetics. And the third type, I'm imagining something very specific.
The third are plant patents. These are granted for new, distinct varieties of plants that are asexually reproduced.
Like a new type of rose.
So if you develop a new rose variety that can only be propagated by cuttings, or a unique strain of fruit tree that could qualify for a plant patent, it's a very specialized but important area.
Fascinating. So it covers everything from complex machinery to a new flower. But a patent document itself isn't just one solid block of text, is it?
Not at all.
It has different sections, and I imagine some are more important for searching than others, especially if you're trying to figure out if your idea is infringing.
Absolutely. Deconstructing a patent document is critical for effective searching and understanding its true scope. There are 4 key components you need to be familiar with.
Okay, what are they?
First, and perhaps the most important for legal analysis, are the claims.
Right, the legal heart you mentioned.
These are the legal definition of the invention. They precisely outline what is protected, word by word, and they form the absolute basis for any infringement analysis.
Okay.
When a company is accused of infringing a patent, it's these claims that their product or process is directly compared against. It's the precise language that defines the legal boundary.
So the claims are the legal fence around the invention, defining the exact property lines, not just a vague description.
Exactly. They define the precise boundaries of protection. Then you have the specification.
The description part.
This is a detailed written description of the invention. It explains how it works, provides examples of its best mode of implementation, and gives crucial technical context.
Okay.
While the claims define the legal scope, the specification provides the rich technical how-to information that makes the invention understandable and reproducible.
And drawings. I often see incredibly detailed drawings in patent documents, sometimes even with numbers labeling every part.
Yes, drawings are visual representations, if applicable, that aid immensely in interpreting the invention.
Makes sense.
They often clarify complex mechanical or structural features that are difficult to convey purely with words. They are not merely illustrations, they are an integral part of the disclosure,
Right.
and often critical to understanding the invention's operation. Finally, there's the abstract.
The quick summary.
This is a brief summary of the invention, typically a paragraph or two. It's incredibly useful for initial relevance screening during a search, allowing you to quickly determine if a patent might be worth a deeper dive without reading the entire document. It's your quick filter.
So the abstract is the elevator pitch, the drawings are the blueprint, the specification is the user manual, and the claims. The claims are the legally binding contract.
That's a great way to put it, yes.
That clarifies a lot.
Huh.
And that brings us to the so what of patent searching. Why do we go through all this trouble? Is it just about avoiding trouble, or is there a more strategic, proactive element here.
You've hit on a crucial point. It's far more than just defensive. There are several critical reasons to conduct a patent search,
Okay.
each serving a distinct purpose for different stakeholders, transforming it from a chore into a strategic advantage.
Like what? What's the first big reason?
The primary goal for an inventor early on is to assess patentability.
Can I even get a patent?
Exactly. This means determining if your invention is truly novel, meaning completely new and non-obvious.
Novel and non-obvious. We'll need to unpack those.
We will. Non-obvious means it's not just an obvious improvement or combination of existing technologies that someone skilled in the field could easily piece together.
Right.
A thorough patentability search helps you meet the fundamental legal requirements for obtaining a patent, and critically, saves immense time, money, and emotional energy by avoiding pursuing a patent for an idea that's already out there or too similar to existing prior art.
Yeah, you don't want that.
Imagine spending years and hundreds of thousands of dollars on an invention only to find it was already disclosed. This search prevents that.
So it's due diligence for your own idea, a reality check, before you invest too much into it. That makes perfect business sense.
Exactly. Next, and vitally important for any business planning to launch a product, is to avoid infringement.
Avoiding lawsuits.
Right? This is about ensuring that a new product or process you're developing or already commercializing won't step on existing active patent rights held by others. Overlooking this can lead to incredibly costly legal challenges, lawsuits, injunctions, damages during commercialization.
Huge risks.
We see this play out dramatically in competitive markets like India, where strong enforcement can significantly impact market entry or even force a company to pull a product. It's about protecting your entire business from potentially ruinous legal action.
That's a huge, almost existential risk to mitigate. So beyond defense, are there offensive or growth-oriented reasons to do this?
Absolutely. Patent searching is crucial for strategic planning. It goes far beyond just avoiding problems.
Okay, how so?
It's about understanding the entire competitive landscape. You can identify who the key players are in a particular technology space, what their R&D focus is, and where they're investing.
Like competitive intelligence.
Exactly. And most excitingly, it allows you to find opportunities for innovation spotting white spaces or gaps in the market where there's little or no existing patent activity.
Gaps.
Signaling ripe areas for new inventions. This directly informs your business strategy, guides R&D direction, and helps you allocate resources intelligently. It's like having a crystal ball for innovation trends.
That's a real competitive edge right there, not just playing catch-up. What about for legal teams once the gloves are off?
For legal teams, it's essential for litigation support. If you're involved in a patent dispute, whether defending your own patent against a challenger or challenging someone else's, searching helps gather crucial evidence to validate or invalidate patents.
Building the case.
It's about building a strong evidence-based legal case. For instance, to invalidate a patent, you'd search for prior art that proves the patent should never have been granted in the first place.
And finally, what about for investors or large corporations looking at growth? Mergers and acquisitions, maybe?
For investors, venture capitalists, or companies looking at mergers and acquisitions, it's about thorough due diligence.
Checking the value.
Before making major investments, licensing technology from another company, acquiring a startup, or buying an entire patent portfolio, you need to rigorously evaluate the patents involved. A thorough search ensures informed decision-making, confirming the actual value, scope, and enforceability of the intellectual property.
Yeah.
You don't want to buy a patent that's easily invalidated or doesn't actually cover the technology you thought it did.
So, for you, the listener, the insight here is that patent searching isn't just a technical requirement or a legal checkbox. It's a profound strategic imperative.
Absolutely.
It's the difference between navigating the innovation landscape blindfolded and having a powerful, illuminated map in your hands.
Well said.
Now that we understand the why, let's delve into the how. There are different types of searches, each serving a distinct purpose.
Right.
And each with its own specific strategy and critical applications, often dramatically illustrated by landmark legal cases.
Yes.
Let's start with what probably feels like the most fundamental one, the novelty search.
Yes. The novelty search is foundational. Its definition and core purpose are to determine if an invention is truly new and non-obvious compared to existing prior art.
Okay, new and non-obvious again.
Before you even consider filing a patent application. This assesses the fundamental viability of your invention in the eyes of patent law,
Right.
answering the crucial question. Has someone already thought of this or something very similar before me?
So it's the absolute first step for any inventor, almost a gut check.
Precisely. You absolutely use a novelty search before filing any patent application. It's about seeing if your new idea has already been disclosed in prior art, which includes not just existing patents, but also published patent applications, and crucially, non-patent literature like scientific journals, conference proceedings, or even publicly available product manuals
Anything public, really.
that were published before your invention's conception or filing date. The goal is to uncover anything that could invalidate your claim of novelty.
That sounds incredibly thorough. What are the steps involved in conducting a really robust novelty search? Is there a systematic approach that applies globally?
There is, and it's a detailed, multi-layered process. We can think of it as a 7-step strategy adaptable for global reach.
Okay, step 1.
1. Brainstorm terms. You start broadly, and then refine. List every single keyword, synonym, technical term, and even layman's term related to your invention.
Like for that light bulb example.
For instance, if you've invented an energy-efficient light bulb, you'd brainstorm terms like LED, energy-saving lamp, low-power lighting, solid-state lighting, luminaire, and anything else that describes its function, components, or purpose.
Got it. Be comprehensive.
Think like a human than like a machine.
Okay, step 2.
2. Identify classifications. This is crucial for cutting through keyword noise and finding truly relevant patents that might use different terminology.
The CPC and IPC codes.
Yes. Use hierarchical classification systems like the Cooperative Patent Classification, CPC, or the International Patent Classification, IPC. For our light bulb example, you might delve into CPC F21,
Right.
which broadly covers lighting, and then narrow down to specific subgroups within it. These classifications help you find highly relevant patents that might not pop up with your initial keywords alone.
So it's like a subject search in a library. Step 3.
3. Search issued patents. Now you begin using the actual databases. Tools like USPTO, Patent Public Search for U.S. Patents, or a SpaceNet for global patents, are excellent for finding granted patents.
Using the keywords and classifications.
You combine your carefully chosen keywords with the classifications you identified.
Makes sense. 4.
4. Review front pages. Once you get your results, you don't read every single patent end-to-end. That would be impossible.
Right, too much.
You quickly screen for relevance by reviewing titles, abstracts, and inventor-assigned names. This acts as a rapid filter to identify potentially relevant documents for a deeper dive.
Okay, initial scan. Step 5.
5. In-depth review. For the patents that seem truly relevant, you then conduct a more in-depth analysis.
Reading the details.
This means meticulously focusing on the claims, remember, the legal heart, and the specification. You need to see if they completely disclose your invention or key novel elements of it. This requires careful reading and understanding of the technical details.
Okay, 6. Almost there.
6. Search published applications. Don't stop at issued patents. Published patent applications are also considered prior art, even if they haven't been granted yet.
Ah, important point.
They represent what someone else has already filed and publicly disclosed. Tools like WIPO PatentScope are excellent for searching these global applications.
And finally, step 7.
7. Broaden search. Finally, you broaden your search beyond just patent documents. Extend it to foreign patents using platforms like The Lens, which has vast global coverage.
And not just patents, right?
And critically, include non-patent literature, scientific journals, academic papers, conference proceedings, technical manuals, even old product catalogs.
Wow, really broad.
Sometimes a core idea might have been published in a research paper long before it was patented, or might never have been patented at all, yet it still constitutes prior art that could invalidate your invention.
That sounds incredibly thorough, almost exhaustive. Can you give us a real-world example where a novelty search was pivotal, perhaps for a multi-million-dollar product?
Absolutely. Let's look at the case of Takeda Chemical Industries, LTDV Alphafarm Polity, Ltd.
Right, what was that about?
This involved a patent number 4,687,777 related to pioglitazone, a diabetes treatment. Takeda, the original patent holder, sued generic manufacturers like Alphafarm for infringing their patents.
A big drug battle.
Yes. The core of the case involved proving the validity of Takeda's patent against prior art that Alphafarm sought to introduce.
Trying to invalidate it.
Exactly. The court found Takeda's claims to be non-obvious, underscoring how a truly thorough novelty search is absolutely critical in establishing patent validity.
So Takeda's initial search held up.
It seems so.
Yeah.
In pharmaceutical litigation, especially with complex chemical compositions and therapeutic uses, a single scientific paper published years prior, even in an obscure journal, could disclose the core innovation, rendering the patent invalid.
Five takes.
Takeda's success in defending their patent speaks volumes about the original novelty search and the evidence they could present that no prior art rendered their invention obvious. This wasn't just about a chemical formula. It was about ensuring the invention truly represented a new and non-obvious step forward in medicine, justifying its immense market value.
That really drives home the importance of starting with that strong foundation. Now, moving on. Once you've established your invention as novel, what's the next big hurdle for a business bringing a product to market?
Good question.
I imagine it's not enough to just invent. You have to make sure you can sell it.
Precisely. That's where the freedom to operate, FTO search, comes in, often referred to as a clearance search.
Freedom to operate. Okay.
Its definition and purpose are to identify any active, in-force patents held by other parties that might be infringed upon if your product or process is commercialized.
So finding potential roadblocks from others.
This is absolutely crucial for avoiding legal risk before you launch anything, especially in crowded markets. You might have a novel invention, but you need the freedom to operate it without stepping on someone else's legal toes.
So it's about making sure the path is clear for your new product, making sure you don't accidentally become a target for a lawsuit. When do you typically use this kind of search?
You use an FTO search every single time you're contemplating launching a new product, entering a new geographic market, or even starting a new manufacturing process.
Before any major move.
It's a proactive, defensive measure to mitigate potentially devastating infringement risks. The steps involved include:
Okay, what are the steps?
1. Identify all aspects of your invention or product that could potentially infringe. This means dissecting your product's features, components, and the processes used to make it.
Break it down.
2. Search for patents covering similar technologies using global databases like Google Patents, SpaceNet, or WIPO Patent Scope.
But focused differently than novelty.
The absolute key here is to focus specifically on active patents, those that are still in force, have not expired, and haven't lapsed due to unpaid maintenance fees.
Only the live ones matter here. Got it.
3. Analyze patent enforceability. This is a critical legal step. You verify if the patents you find are still active, in force in the relevant jurisdictions, and if all maintenance fees have been paid.
Check their status thoroughly.
An expired or lapsed patent, even if it covers your invention, poses no infringement risk.
Okay, and step 4.
4. Assess infringement risk. This is where you, often with the indispensable input of legal experts, compare your invention or product directly to the claims of the identified active patents.
Back to the claims again.
You determine if your product reads on falls within the scope of their claims, either literally or under the doctrine of equivalence.
Literally, or doctrine of equivalence. What's that?
We'll get into that, but basically, does it do the same thing in the same way to get the same result, even if it's not identical wording?
Ah, okay. So it's not enough to just find a patent. You need to know if it's still alive, and if your product truly steps on its specific, legally defined claims.
Exactly.
What's a prominent case where an FTO search was critical and perhaps even a lesson in its complexity?
A well-known example is Sanofi Synthalobo v. Apotex, Inc., concerning clopidogrel bisulfate, patent number 4,847,265.
Plavix, the blood thinner.
That's the one, a blockbuster drug. Sanofi sued Apotex to prevent the launch of a generic version.
Right. Generics always do FTOs, I assume.
Apotex, as a generic manufacturer, would have meticulously conducted an FTO search to try and ensure their product did not infringe Sanofi's active patents. The stakes were incredibly high, billions in sales.
Billions, wow.
Despite Apotex's likely thorough FTO, Sanofi's legal arguments prevailed, at least initially, successfully asserting their patent rights.
So the FTO wasn't foolproof.
This highlights that an FTO isn't a guarantee, but a risk assessment. Even a thorough search and positive FTO opinion don't eliminate all risk, as patent law involves nuanced interpretations and litigation outcomes can be unpredictable.
So it reduces risk, but doesn't eliminate it.
The lesson here is that an FTO search reduces, but does not eliminate, risk, and often requires aggressive legal defense even with a favorable FTO.
That's a huge lesson in how critical and complex FTO searches can be, even for the most prepared companies. Beyond just avoiding problems, how do companies use patent data for broader strategic insights, almost like a technological radar?
That leads us to the state-of-the-art search.
State of the art. Okay.
Its definition and purpose are to provide a broad, high-level overview of the current technological landscape in a specific field.
Like a snapshot of what's happening now.
It's about mapping the terrain, identifying emerging trends, spotting technological gaps, and pinpointing the key players and their areas of focus. This directly aids R&D efforts and informs overarching strategic planning.
So it's about taking the pulse of an entire industry, rather than just looking for one specific patent or whether you're infringing.
Exactly. You use this constantly during your research and development phases to stay informed about technological advancements, identify where innovation is hot, and, crucially, to identify emerging innovation opportunities. Think of rapidly evolving fields like artificial intelligence, quantum computing, or renewable energy without a state-of-the-art search. You're innovating in the dark.
How do you even begin to approach such a broad search without getting completely overwhelmed by data? Seems like you'd get millions of hits.
The steps involved typically start with using broad keywords and classifications to map the technology area.
Broad approach first.
For example, if you're interested in autonomous vehicles, you might start with those keywords and combine them with a broad CPC class like B60W, which covers vehicle control systems.
Okay.
Then you analyze patent trends, looking at filing dates over time to see where activity is increasing, who the assignees, the companies or institutions are,
Who owns the patents?
and the geographic distribution of patents to see where R&D is concentrated. Tools like the Lens are excellent for this kind of analytical work because they can visualize these trends.
Seeing the patterns.
Finally, you use this information to identify emerging technologies and, crucially, market gaps areas where there's relatively low patent activity, indicating potential for new inventions or underserved niches.
Finding the openings. Can you give us a concrete example of this in action, perhaps from the pharma world?
Certainly. Consider drug discovery. A pharmaceutical company's R&D team might conduct a state-of-the-art search to understand the latest developments in, say, immunotherapy for cancer.
Hot area.
This kind of search wouldn't just pull up specific drug patents, it would reveal which research institutions are most active, which big pharma companies like Novartis or Gilead are filing the most patents in this space,
The key players.
what new biological pathways are being explored, and, most importantly, identify potential areas for new cancer treatments where innovation is needed or where there's a current gap in the patent landscape.
So it guides the research focus.
This directly supports and shapes their R&D direction, saving years of misdirected research.
That really illustrates how strategic this kind of search is. Now let's talk about a search type that comes into play when a patent is already out there, perhaps even being challenged in court.
That would be the validity search, also sometimes called an invalidity search, depending on your goal.
Validity. Checking if it's solid.
Its definition and purpose are to find prior art that could invalidate an existing patent. This means proving that the patent should never have been granted in the first place,
Well,
because it lacks novelty or is obvious based on information that was publicly available before its filing date.
digging up old dirt, basically.
It's most commonly used in high-stakes litigation, where a patent's enforceability is being challenged, or during critical due diligence processes before an acquisition or licensing deal.
So if someone is trying to challenge a patent that's been granted, or buy one, they'd use this to check its foundations.
Precisely. You use a validity search during patent litigation, in licensing negotiations to assess the value of the patent being licensed, or before acquiring a patent or a company with a patent portfolio. It's about assessing the strength and enforceability of that patent, determining just how rock solid it truly is, and whether it could actually stand up if challenged in court.
How do you do that? What are the steps?
The steps involved are: 1. Identify the claims of the patent in question. Remember, these are the legal fence posts. You must understand exactly what the patent claims to protect.
Focus on the claims again.
2. Search for prior art. Any publicly available information, be it patents, publications, or even public demonstrations, that predates the patent's original filing date.
Going back in time before the filing.
This is a critical temporal element. You'd use a wide array of databases for this, including USPTO Patent Public Search, WIPO Patent Scope, a SpaceNet, and also non-patent literature databases. Very broad search.
Leave no stone unturned. Then what?
3. Analyze whether that prior art anticipates or renders obvious the claims.
Anticipates or renders obvious, what's the difference?
Anticipates means the prior art discloses every single element of the patent's claims, exactly as claimed in a single reference.
An exact match.
Renders obvious means that Even if not every element is explicitly stated in one place, the combination of known elements in the prior art would have been obvious to someone skilled in the art at the time the invention was made.
New obviousness hurdle again.
This is a highly nuanced and often subjective assessment that frequently requires specialized legal interpretation and expert testimony.
That sounds like a heavy lifting search, capable of derailing major products. Is there a big case that hinges on this?
A prime example is Pfizer, Inc. v. Ranbaxy Laboratories, Ltd., concerning atorvastatin calcium, patent number 5,273,995.
Lipitor, the cholesterol drug. Huge case.
This was a significant multi-billion-dollar battle over Lipitor, Pfizer's blockbuster cholesterol drug. Pfizer sued Ranbaxy for infringement when Ranbaxy sought to introduce a generic version.
Right.
Ranbaxy, in defense, performed a rigorous validity search to challenge Pfizer's patent.
Trying to knock it out. What happened?
Ultimately, the Federal Circuit ruled against Pfizer due to an improper claim from a specific legal technicality.
A technicality sunk Lipitor's patent.
The core insight for you is that this wasn't just a technicality. It was a multi-billion-dollar lesson. The specific issue, the improper claim form, is precisely something that a rigorous validity search, focusing not just on prior art, but also on the legal and formal aspects of the patent itself, could certainly have identified.
So the validity search looks at legal form, too, not just prior art.
Potentially, yes.
Yeah.
A thorough one should. This case vividly shows how even a seemingly minor error in drafting the claims, the legal fence around your invention, can unravel years of R&D and lead to losing control over a blockbuster drug.
Wow.
Even if your invention is groundbreaking. It underscores that meticulous legal precision in patent drafting and the search to validate it is as critical as the innovation itself.
So a validity search isn't just about finding prior art. It's about finding any weakness in an existing patent.
That's a good way to think about it.
What if you already have a product on the market and you're worried it might be stepping on someone else's toes, or worse, someone is accusing you of it?
That's where an infringement search comes into play.
Okay, this sounds direct.
Its definition and purpose are to determine if a product or process already infringes on an existing patent's claims. It's used to assess legal risk, either proactively before a full-scale product launch or, more commonly, in response to a direct accusation or claim from a patent holder.
So it's about playing defense or confirming a suspicion about whether your product, as it currently exists, is violating someone else's rights.
Exactly. You'd use it before launching new products, entering significant partnerships where intellectual property sharing is involved, or, as you said, when responding to a patent holder's claim letter.
How does this search work?
The steps involved are very precise. 1. Obtain detailed information about the accused product or process. You need to know its exact features, how it's constructed, and how it functions. This often involves reverse engineering or detailed schematics.
Get the specs of your product.
2. Compare it directly, element by element, to the claims of the patent in question. This is not a casual comparison. It's a methodical, often painstaking analysis of whether every element of a patent's claim is present in the accused product or process. Every single word in the claim matters.
Element by element comparison to the claims.
Okay.
Step 3.
3. Determine if the infringement is literal or under the doctrine of equivalence.
That doctrine again. Explain that.
Literal infringement means a direct, word-for-word match between your product and every element of a claim.
Clear cut.
The doctrine of equivalence is more complex. It means the accused product performs substantially the same function in substantially the same way to achieve substantially the same result.
Function, way, result.
Okay, even if it's not a literal match, this requires sophisticated legal interpretation.
So, if I'm understanding this right, it means even if you tweak your invention just enough to avoid a word-for-word match with the patent's claims, if it still essentially does the same thing in the same way to get the same result, you could still be infringing. It's about the spirit of the invention, not just the exact blueprint.
You've nailed it. It's about preventing inventors from making minor, insubstantial changes to avoid infringement. This nuance is precisely why legal expert consultation is almost always essential for an infringement analysis.
Is there a pharmaceutical example that showcases the real-world application of this precise legal analysis?
Yes. Considered in Re 318, patent infringement litigation involving galantamine, patent number 4,663,318.
Alzheimer's drug.
Janssen, the original patent holder, sued generic manufacturers over patents related to galantamine, a drug used for treating Alzheimer's disease.
Okay.
In this case, the generic manufacturers actually conceded infringement of certain claims.
They gave up. Why?
This almost certainly happened after they conducted an infringement search and analysis that definitively confirmed their generic products did indeed match the patent claims, both literally and under the doctrine of equivalence.
Their own search showed they were infringing.
Exactly. This is a clear illustration of the real-world application and consequence of infringement searches in the pharmaceutical markets, where even slight chemical or manufacturing variations can lead to significant, high-stakes legal battles.
Right.
It proved invaluable for Janssen in defending their IP, and for the generics in making informed decisions about their legal strategy.
Fascinating how these searches play out in actual court battles, shaping entire industries. Given the breadth of these searches we've discussed, how do companies get a comprehensive, almost aerial view of an entire technological field, not just one invention or one patent?
That's when you perform a patent landscape analysis.
Landscape analysis. Sounds big picture.
Its definition and purpose are to provide a much broader, comprehensive mapping of the patent environment. It helps identify key players, overarching technology trends, and innovation opportunities across an entire technology area.
Broader than state-of-the-art.
This is significantly broader and more strategic than even a state-of-the-art search, which tends to focus on current developments. A landscape analysis looks at the past, present, and hints at the future.
So it's like a full topographical map of the innovation space, showing mountains, valleys, and unexplored territories.
Exactly.
When is this most useful for a business?
It's absolutely vital for high-level strategic planning, setting long-term R&D direction, and in-depth competitive analysis, especially when a company is considering entering entirely new markets or industries or making a major pivot.
Big strategic moves. How is it done?
The steps involved are quite extensive. 1. Conduct a comprehensive search across multiple databases like USPTO, SpaceNet, and the Lens, using a wide range of keywords, classifications, and even assigned names.
Casting a very wide net.
This isn't about finding specific prior art, but about gathering a massive data set.
Okay, then what do you do with the data?
2. Analyze patent ownership, looking at which companies or assignees hold the most patents in a given field, identifying their core strengths and weaknesses.
Map the players.
Also, analyze technology areas using CPC codes and filing friends over time to see where activity is increasing, decreasing, or stagnating. This can reveal where the industry is heading.
Follow the trends.
3. Identify white spaces. These are the exciting areas with little or no current patent activity, indicating potential for significant innovation and market entry without immediate heavy competition.
Find the opportunities.
You also clearly identify key competitors, their IP portfolios, and their likely future R&D strategies based on their patent filings. This is where you connect the dots between patent data and business strategy.
Can you give us an example where this would be critical, perhaps in a cutting-edge industry, like EVs?
Imagine a major automotive company planning to aggressively enter the electric vehicle EV market, beyond just their traditional combustion engines. They would conduct an extensive patent landscape analysis.
Okay.
This analysis wouldn't just tell them what's patented in general EVs, but would dissect specific sub-technologies like battery management systems under CPC H01M, charging infrastructure, or autonomous driving features.
Break down the tech areas.
They would understand which technologies are heavily patented by leaders like Tesla, BYD, or traditional auto giants, and crucially, identify opportunities for differentiation.
Find their unique angle.
This could mean focusing R&D on specific white space battery chemistries or novel charging methods, allowing them to innovate in areas that aren't saturated with existing IP. Or identify companies ripe for acquisition to bolster their own portfolio. It literally shapes billion-dollar investment decisions.
That's a truly powerful strategic tool, giving a 30,000-foot view of an entire innovation ecosystem. And finally, we talked about design patents earlier, purely aesthetic. How do you search for those specifically, since it's not about function?
That's covered by a design search.
It makes sense.
Its definition and purpose are to ensure that a new product design is truly unique and doesn't infringe on any existing design patents. The focus here is purely on aesthetics, on the ornamental appearance, not how the product works.
So if I'm designing a new consumer gadget or a unique furniture piece, this is critical to avoid copycat accusations.
Exactly. You use it extensively for product design in any industry where visual appearance is paramount and a key differentiator,
Right.
such as fashion, furniture, consumer electronics, or even the user interface of software.
How's it done? Is it just looking at pictures?
The steps involved are straightforward. but require a keen eye for visual detail. 1. Search design patent databases, such as the USPTO's dedicated design patent collection, which has its own classification system, D classes, or WIPO's global design database, Hague Express.
Specific databases for designs.
2. Compare your new design with existing designs for similarity, focusing intently on the ornamental features. This often involves visual comparison tools and very careful side-by-side analysis, looking for overall visual impression, patterns, shapes, and configurations.
And has there been a landmark case for design patents that really drove home their importance? Apple, Samsung, maybe?
One of the most famous, of course, is Apple Inc. v. Samsung Electronics Co., Ltd. Apple sued Samsung for infringing its smartphone and tablet design patents.
Yeah, I remember that.
Alleging that Samsung's devices copied the look and feel of the iPhone and iPad. This involved extensive design searches and highly detailed legal arguments.
Rounded corners and all that.
Literally comparing the visual appearance of their products down to the rounded corners, the bezel, and the grid of icons. It sounds almost absurd, but billions of dollars in market dominance hinged on those incredibly detailed design searches and their interpretation.
Billions on aesthetics.
This case vividly highlights the immense importance of design searches in high-stakes industries where visual brand identity and user experience are crucial, with outcomes significantly affecting market competition and profits.
Wow.
It's a reminder that beauty in the patent world can be incredibly valuable.
If we connect this to the bigger picture, you can see how patent searching isn't just a legal chore, but a strategic imperative that shapes entire industries.
Absolutely.
From pharmaceuticals to consumer electronics, dictating who wins and who loses. It's truly comprehensive.
It really is.
Knowing all this, the next logical step is to arm ourselves. So let's turn our attention to the incredible arsenal of tools at your disposal, many of them surprisingly free, that put this power directly into your hands.
Indeed. First, we have the USPTO Patent Public Search.
The official U.S. one.
This is the free, web-based tool provided directly by the U.S. Patent and Trademark Office. If you're focusing on the U.S. market or U.S.-based prior art, this is your foundational go-to for searching U.S. patents and published applications.
What are its best features, and how does someone new to it get started? Is it user-friendly?
It offers both basic and advanced search options, allowing you to search by keyword, patent number, inventor, or assignee. You get full text access to patents, which is invaluable.
Full text is good.
And you can even export results for further analysis. Crucially, it fully integrates with the CPC classification system we just discussed, which is a massive plus for structured, precise searches.
CPC integration, nice. How do you use it?
To use it, you'd visit their website and choose between a simple quick search for basic keyword queries, or dive into the advanced search interface to combine keywords with classifications using Boolean operators for much more refined results.
Okay.
It's where many patent professionals start for U.S.-specific inquiries.
Next up, one that probably most people have heard of and probably tried for a quick search, Google Patents. But I imagine there's more to it than just a simple search bar.
Google Patents is incredibly user-friendly and boasts impressive global coverage.
Global coverage, key difference.
Pulling patents in around the world, including U.S., European Patent Office, EPO, WIPO, World Intellectual Property Organization, and even Indian patents.
Wow, okay, features.
Its key features include full-text search across this vast database, excellent citation analysis to quickly find related patents that cite or are cited by your initial result.
Citation links are useful.
And, perhaps most importantly, access to non-patent literature directly linked to patent results, which is crucial for comprehensive prior art searches.
MPL, non-patent literature. Good.
It also supports robust advanced search operators like AND or NOT and proximity searches, making it quite powerful despite its deceptively simple interface.
So it's powerful under the hood.
You just enter your keywords, like solar panel efficiency, or use operators for refined results, and Google's algorithms often provide very relevant initial hits.
And then there's the lens. That sounds intriguing, especially with its open access model. What's its angle?
The lens is truly a gem in the patent searching world. It's an open access platform for both patent and scholarly search.
Patent and scholarly. Interesting.
Boasting coverage of over 141 million patents from more than 90 countries, including comprehensive Indian coverage.
Huge database.
Its key features are its powerful keyword and classification search, the ability for bulk data download for large-scale analysis.
Bulk downloads. Good for big projects.
And its seamless integration with scholarly literature, which is incredibly useful for state-of-the-art and landscape analyses. It also champions privacy, which is a nice bonus.
So it's great for those bigger strategic searches.
It's particularly useful for those broader strategic searches, leveraging its extensive global coverage and direct links to academic research, allowing you to see the scientific basis behind patented innovations.
So it connects academic research to patents. It's powerful. What about the European Patent Office's tool, a SpaceNet? I imagine that's a must for anyone operating internationally.
Absolutely. The European Patent Office provides a SpaceNet, a truly comprehensive database covering patents from over 100 countries, again, including detailed Indian patents.
Another global player. Features.
Its features include robust search capabilities by keywords, both CPC and IPC classifications or patent numbers, with full text access to many documents. It also has excellent tools for analyzing patent families.
Patent families, what's that?
Which helps you identify all related patents for an invention across different jurisdictions and languages. So the same invention filed in the US, Europe, Japan, etc.
Track it globally.
Yeah.
Smart.
Yeah. Ensuring you don't miss crucial protection in different markets. It also offers multilingual search, which is invaluable for global searches. Its global coverage makes it indispensable for international deep dives.
And WIPO Patent Scope, what's its unique strength? Seems like there's overlap.
WIPO Patent Scope is the World Intellectual Property Organization's database, which is paramount for covering international patent applications, famously known as PCT, Patent Cooperation Treaty applications.
PCT applications, okay.
Alongside national patents, including Indian filings, its key features include searching by keywords, classifications, or patent numbers, with robust tools for patent analytics, like trend analysis and legal status checks across multiple jurisdictions.
Legal status checks, that's handy.
It also supports searches in multiple languages and offers very detailed legal status information, further enhancing its global reach. This is essential for anyone focusing on international patenting strategies or PCT applications, as it provides a centralized view of global filings.
And finally, for those in India, or anyone with a specific focus on the Indian market, there's a crucial official database, right? You mentioned the IPO and patent.
Absolutely. The Indian Patent Office, IPO, IMPAS, is the official database for Indian patents. It's essential for anyone with an India-specific focus,
Kind of use the official source.
as it provides the most authoritative and up-to-date information on Indian patent filings. Its features are very specific and robust, allowing you to search by title, abstract, complete specification, application or publication or patent numbers, applicant or inventor name, IPC classification, PCT numbers, and even the filing office.
Lots of specific fields.
You get access to both published applications and granted patents, with their full application status and history.
How would someone practically navigate INCAS effectively? Let's say I want to find all published Indian patents related to drones from the last 5 years. How would I go about that?
Okay, let's walk through that specific scenario. You'd visit the IPR Search website, which hosts IMPAS. First, you'd select the Publish Applications radio button as you're looking for recent disclosures.
Check the Publish box.
Then, under Search category, you'd likely choose Title, Abstract, Complete Specification to cast a wide net for your keywords.
Search everywhere in the text.
In the search term box, you'd type drone or unmanned aerial vehicle, maybe even UAV.
Put in the keywords.
You could then use the publication date field to specify a range for the last 5 years. After entering the CAPTCHA, you hit search.
Okay, makes sense. And what would I see in the results? How is it presented?
Your results page would display a list of relevant applications. For each, you'd see the application number, title, publication date, current status, like published, under examination, or granted.
The status is key.
Classification codes, IPC, and details of the inventor and applicant. You can then click on individual application numbers to view the full abstract and the complete specification document, along with any drawings.
So you can drill down.
What's particularly useful is the ability to view the application status for detailed updates, seeing if it's been refused, registered, withdrawn, abandoned, or is still pending. This gives you a real-time snapshot of the patent's journey through the Indian system.
This raises an important question. With all these incredible tools, how do you decide which one to use? It sounds like a multi-tool approach is key, but is there a logic to picking your primary weapon for a given hunt?
You've hit on the essence of effective searching. Knowing the tools is one thing. Using them effectively to yield precise and comprehensive results is another entirely.
Right.
There isn't a single best tool. Rather, it's about choosing the right combination for your specific search objective.
Tailor the tools to the task.
For a global novelty search, you might start with Google Patents or the lens for broad coverage, then refine with a SpaceNet and WIPO patent scope for international family details.
Layering the searches.
And finally, drill down into USPTO for US-specific nuances and INPASS if India is a key market. It's truly a multi-tool, multi-step approach.
That's a perfect transition. So let's explore the strategies and techniques that truly yield precise and comprehensive results when using these tools. How do we master the hunt, moving beyond just typing a word into a search bar?
It all starts with keyword searching techniques, but with a strategic mindset.
Okay, keywords first.
First, brainstorming keywords is paramount. You need to start broadly, then refine relentlessly. List every synonym, technical jargon term, and even layman's terms that describe your invention, its components, its function, and its application.
Like we did for the light bulb.
For example, for a solar panel invention, you wouldn't just search solar panel. You'd also include photovoltaic cell, solar energy converter, renewable energy device, solar power system, and even the raw materials involved, like silicon wafer.
Think broadly about terms.
The goal is to anticipate all the different ways an inventor or researcher might have described a similar concept.
And once you have all those keywords, how do you make sense of them? Especially if some are very similar or some are completely different but related, how do you combine them effectively?
That's where Boolean operators become essential for precision. They allow you to build sophisticated search queries.
And D or not.
You use and D to find documents that contain both terms, like solar and D efficiency. This narrows your results.
Both terms needed.
Use or to find documents with either term, which broadens your search, such as solar or photovoltaic.
Either term is okay.
And not allows you to explicitly exclude a term, which can be incredibly useful for refining away irrelevant results. For example, drone, not military.
Exclude things you don't want.
This allows you to construct very specific, powerful queries. You can also use field-specific searches,
Searching only in certain parts.
limiting your search to particular fields within the patent document, like the title, abstract, or claims. Searching solar only in the title field, for instance, focuses your results on patents where solar is a primary central topic, leading to much higher relevance.
So keywords get us started, and Boolean operators give us precision. But you mentioned classifications earlier, like CPC and IPC. They sound more structured, less reliant on specific word choices. How do they fit into effective searching?
Classification searching is incredibly powerful for finding highly relevant patents, often cutting through the noise that pure keyword searches can generate,
Okay.
especially if different terminology is used. You need to understand CPC, the Cooperative Patent Classification System,
The global standard.
which is jointly developed by the USPTO and EPO, or IPC, the International Patent Classification. These are hierarchical systems that categorize patents by technology.
Like a Dewey Decimal System for tech.
It's structured into incredibly detailed sections, classes, subclasses, groups, and subgroups, like a massive library catalog for inventions. For instance, CPC H01L covers semiconductor devices, which includes very specific subgroups for different types of solar cell technologies.
So instead of just words, you're using a universal filing system for technologies. That sounds incredibly efficient, almost like a secret code.
Precisely. To use it, you first identify the relevant CPC codes for your invention.
How do you find the right codes?
Resources like the USPTO's CPC Scheme Search or a SpaceNet's classification browser can help you navigate this intricate system.
Hey, tools exist for that.
Once you have those codes, you search specifically within those classifications. This allows you to find highly related patents even if they use different terminology or obscure keywords that you might not have thought of in your initial brainstorming.
Find things keywords might miss.
It's particularly effective for broad state-of-the-art and landscape searches.
That sounds incredibly efficient.
Sure.
Are there other advanced techniques that go beyond basic keywords and classifications, almost like a linguistic scalpel, getting really precise?
Yes, there are several that give you even finer control. Proximity searches are incredibly useful.
Finding words near each other.
They use operators, often near, ADJ, adjacent, or specific numbers, the example W5 for within 5 words, to find terms that appear close to each other in the document. For example, solar near efficiency. would find documents where these two terms appear in close proximity, significantly improving relevance compared to just solar AND efficiency, because it indicates a stronger conceptual connection.
That's smart, connecting the ideas and their relationship. What else? Any other tricks?
Wildcards are another helpful technique. These are symbols like an asterisk or a question mark,
Like in regular search engines.
used to account for spelling variations or different word forms. For instance, searching solar would include solar, solar-powered, solarization, and so on.
Catches variations.
This broadens your search for variations of a root word without having to type them all out. And finally, date ranges allow you to limit your searches to specific time periods.
Filtering by time.
This is vital whether you want to focus on recent innovations, perhaps patents filed after 2020 for cutting-edge technologies, or historical prior art relevant to an older invention for a validity search. It filters out irrelevant temporal noise.
So you've done all this meticulous searching, you've used all these clever techniques, and now you have a pile of results. This isn't the end, is it? Seems like the hardest part might be next.
Not at all.
You have to analyze them critically, almost like a detective.
Yeah.
What's the most crucial part of this analysis?
Absolutely. Analyzing search results is arguably the most critical evaluation phase where expertise truly shines.
Okay, what's key here?
The most crucial step is relevance evaluation. You need to ask yourself, is the prior art truly prior? Meaning, was it published before your invention's filing date?
The timing is everything.
A patent published in 2024, for instance, cannot be prior art for an invention you filed in 2025. And does it disclose all elements of your invention, or at least the key ones? You're looking for the closest matches, the teaching that might invalidate your idea.
That distinction between prior and not prior is fundamental. And you mentioned claims earlier as the legal heart. Do they come back into play heavily here? Because it seems like the entire search funnels back to those claims.
They absolutely do. You must stress the importance of understanding claims. As we said, they define the scope of protection.
Right, the fences.
When analyzing results, you need to dissect whether the prior art anticipates your claims, meaning it discloses every single element of your claim precisely as worded in a single document.
The exact match standard.
Or if it renders the claims obvious, meaning that a combination of known elements in the prior art would have made your invention obvious to someone skilled in the field at the time you invented it.
Obviousness again.
Yeah.
Harder to judge.
This is a highly nuanced, often difficult assessment that separates a good search from a great one. It's rarely black and white.
So it's not enough to just find a similar document. You have to be able to argue definitively, based on the claims, why it invalidates or makes obvious.
Precisely.
And finally, how do you determine what actually counts as valid prior art, beyond just patents? You mentioned non-patent literature.
To determine valid prior art, you need to ensure the document or disclosure qualifies under patent law. This includes patents, published applications, and non-patent literature, like scientific papers, conference proceedings, academic theses, even public demonstrations of an invention.
Wow, demos count.
But they all must have been publicly available before your invention's effective filing date. It's also vital to remember that jurisdictional rules apply.
Ah, country rules matter.
For example, in India, prior art is precisely defined under Section 13 of the Patents Act 1970, which includes anything published anywhere in the world before the priority date. These definitions can vary globally. So what counts as prior art in one country might have slightly different nuances in another.
This raises an important question. You could have all the tools and keywords, but if you don't critically analyze the results with this level of legal precision, you might miss the crucial details
You could.
that determine validity or infringement, potentially leading to massive legal exposure. It sounds like the analysis phase is where true expertise truly shines.
Indeed. It's where the art of searching meets the science of legal interpretation. And to truly master patent searching, it's not just about the technical steps, but also adopting best practices and understanding the underlying legal landscape that governs everything.
So, what are the absolute best practices for success in this intricate world of patent searching, especially for someone who wants to do it right? How do you stay organized and thorough?
First and foremost, document your search thoroughly. This means keeping incredibly detailed records of every single step you took.
Keep a logbook.
All the search terms you used, the specific databases you accessed, the exact dates of your searches, and all key results you found. Why?
Why is that so critical?
Because it aids reproducibility if you need to revisit it, and it's absolutely vital for legal defensibility if your search ever comes into question in a court or patent office.
Proof of your work.
Think of it like this. Note the exact query solar near efficiency conducted on August 4, 2025 via USPTO's advanced search, yielding 75 results, with document X being the closest match. That level of detail is a must.
That makes perfect sense for auditing your work later, proving your due diligence. What else? Any other core practices?
Use multiple databases. Never, ever rely on just one.
Don't put all your eggs in one basket.
They need to cross-check your results across different tools: USPTO, Google Patents, the Lens, SpaceNet, WIPO Patent Scope, and especially InPass for Indian patents.
Uses the whole arsenal.
Each database has unique coverage, different indexing, and varying update schedules. Combining them ensures the most comprehensive results and helps catch anything one database might miss. It's like using multiple lenses to get a complete picture.
So a single source of truth isn't enough here. You need multiple lenses to ensure you're truly comprehensive. Makes sense. What about when it gets really tricky?
Exactly. And for complex cases, particularly if you're involved in litigation, dealing with international contexts, or working in highly specialized technical fields, you should absolutely seek professional help.
Know when to call an expert.
Consult experienced patent attorneys or professional patent search firms. Resources like India filings, for instance, offer localized expertise that can be invaluable for ensuring accuracy and navigating specific legal nuances that a layperson might miss.
Right.
Knowing when to call in the experts is a sign of wisdom, not weakness.
And what are some common pitfalls or mistakes that people often make when trying to do these searches themselves that our listeners should actively avoid?
Avoid common mistakes like relying solely on keyword searches.
We covered that keywords aren't enough.
As we discussed, that can miss highly relevant prior art that's classified differently or uses unexpected terminology. Also, a huge pitfall is neglecting foreign patents or non-patent literature.
Forgetting the global picture and academic stuff.
Many crucial disclosures happen outside of your primary jurisdiction or in scientific publications long before they ever become a patent. Ignoring these can leave massive holes in your search and expose you to significant risk. Another common mistake is failing to analyze the claims meticulously, getting distracted by the specification or drawings, and missing the actual legal boundaries.
Always come back to the claims.
Yes.
So it's about being incredibly meticulous, knowing when to ask for help, and understanding that the rules of the game can change depending on where you're playing globally.
Precisely.
That brings us to the key legal considerations. What are the bedrock concepts you need to grasp to truly understand the results of your searches? Let's nail these down.
The first is prior art. We've mentioned it a lot, but to reiterate, it includes any publicly available information that predates the invention.
Anything public before you filed.
This has a very broad scope. Patents, published applications, scientific papers, conference proceedings, journal articles, even public demonstrations, or products that were sold or offered for sale.
Really broad.
And critically, how it's defined and what counts is governed by specific jurisdictional rules. For example, in India, prior art is precisely defined under Section 13 of the Patents Act, 1970, which makes it clear that anticipation can come from any publication anywhere in the world.
Check the local law. Got it.
And the distinction between novelty and non-obviousness seems to come up repeatedly as the two fundamental tests for patentability. Can you clarify those distinct legal concepts, perhaps with a simple analogy?
Yes, they're often confused but are fundamentally different tests for patentability, each a distinct hurdle. Novelty means the invention is genuinely new.
Brand new.
Has this exact thing, exactly as you've claimed it, existed before in any public form. If even one prior document describes your entire invention precisely, it's not novel.
Okay.
Think of it as finding a pristine, untouched artifact. It's truly unique.
Simple enough. What about non-obviousness?
Non-obviousness, on the other hand, means that even if the individual elements of your invention are known, the invention itself is not an obvious improvement or combination over existing technology.
To someone skilled in that particular field. It requires an inventive step, something surprising.
The inventive step.
For example, combining a pen and a cap is not novel if pens and caps exist. But the combination of a pen and a cap in a way that creates a new, surprising, or unexpected function might be non-obvious.
All right.
In India, this is assessed under Section 2(1) of the Patents Act. It's a much higher, more subjective bar than just being new, and often the most challenging aspect to prove.
So, novelty has this exact thing existed before, while non-obviousness is, could any smart engineer have easily come up with this just by combining existing ideas, or was there a genuine spark of inventive genius?
That's a good way to capture it.
It sounds like the non-obviousness test is often the tougher hurdle to clear, isn't it?
It absolutely is the tougher hurdle. Many inventions are novel, but fail the non-obviousness test because they're simply logical next steps. That's where a rigorous novelty search truly matters, because it helps you identify the closest prior art that your invention needs to distinguish itself from, particularly on the non-obviousness front.
And finally, what about jurisdictional differences? It seems like patent law isn't a one-size-fits-all global system. You hinted at this with India.
This is huge. Patent laws vary significantly by country, and assuming uniformity is a major mistake.
Can't assume U.S. law applies everywhere.
What can be patented, how searches must be conducted, and what constitutes infringement can differ widely. For example, India has specific exclusions under Section 3 of its Patents Act that might not exist elsewhere,
Like what?
such as traditional knowledge, methods of treatment, or even mere discoveries of new properties of known substances.
Interesting exclusions.
These exclusions directly impact what can be patented in India and necessitate tailored searches and legal strategies when operating in that jurisdiction. You simply can't assume what's patentable in the US or Europe is patentable everywhere else.
So what does this all mean for you, the listener? It means being incredibly meticulous, knowing when to ask for help from experts, and critically, understanding that the rules of the game can change depending on where you're playing.
Absolutely.
It's a complex world, but one that is absolutely navigable with the right knowledge and tools.
We've taken a truly deep dive today into patent searching, revealing it not just as a niche technical task, but as an essential strategic skill for anyone involved in innovation. From individual inventors with a groundbreaking idea to multinational corporations and, of course, legal professionals.
Yeah.
We've explored the crucial why behind it, dissected the various types of searches with their real-world impact and compelling case studies,
Those cases really brought it home.
unveiled a powerful arsenal of tools, and equipped you with effective strategies and best practices.
This deep dive, we hope, provides you with a comprehensive foundation for mastering patent searching, transforming what might have seemed like a daunting task into a formidable strategic advantage.
That's the goal.
It's about empowering you to navigate the intricate patent landscape with confidence, make truly informed decisions, and protect the fruits of your ingenuity. The real takeaway here is that patent searching isn't just about playing defense. It's an incredibly powerful offensive weapon.
Absolutely. It's proactive.
It's the market research, competitor analysis, and R&D roadmap all rolled into one, allowing you to not just invent, but strategically dominate a technological space.
Now that you have this blueprint for understanding the world of ideas and their protection, what new idea will you explore or protect? What hidden opportunity might you uncover in the vast, ever-expanding landscape of innovation? The power of informed discovery is now truly in your hands.
For those eager to delve even deeper, remember that resources like the USPTO website, India filings guides, and the various webinars offered by patent offices worldwide are excellent places for ongoing updates and continuous learning.
Keep learning, definitely.
Until next time, keep digging deeper and keep innovating.